Next thing we have are some recess appointments for the National Labor Relations Board and the Consumer Protection Bureau. I think Consumer Finance, CFPB.
Well, that's a new. The Consumer Protection Bureau is a new.
But I mean, it's a
new department. That
I think
was
it's a
just
Finance
created.
Protection Bureau or something like that.
Yeah, it's
basically
it's a new regulatory overview of the consumer generally, which kind of goes all over the market.
Well, I think what it does is, like, say for instance, you don't pay your credit cards, they raise your rates. They don't want to do that. They want to raise everyone's rates to cover the people who aren't paying. So it's kind of a, leveling the field on everyone.
Leveling the playing field.
Leveling the playing field.
We're talking about leveling the playing field.
It's a fairness issue.
Is that a redistribution issue?
It's a fairness issue.
Okay, fairness issue.
It's a fairness issue. So that's those, and then the National Labor Relations Board. I don't know if we really call it a fairness issue, but it's pretty pro-labor. 3 folks on that board that were appointed.
Well, I understand that there was 3 appointments, and each of them have direct ties to unions, all either union managers, union organizers, and these were all appointed I understand, while the Senate was allegedly in recess. But what did the court find, Mark?
Well, the D.C. Court, District of Columbia Court of Appeals, struck down the appointments in Noel Canning versus NLRB. And now, what the Justice Department had said was that the President of the United States could decide if the Senate was in session. The executive branch could say, hey, is the Senate genuinely capable of exercising constitutional function? And the President in this case said, well, this is a pro forma gathering of the Senate, and they're not capable of exercising their constitutional function here, so they're in recess. That was the executive.
Time out here. You're telling me that although the pro forma was created under the George Bush presidency by Harry Reid, that the pro forma was being utilized by the Republicans during a non-recess, and then somehow the president tried to appoint people and circumvent the Senate? Is that what we're talking about here, Mark?
Yeah, Senator Reid, the majority leader, when Bush was in power, in 2007, developed this pro forma session response as a means of slowing down appointments or stopping appointments from happening.
Does this mean that Senate's supposed to still be in session then?
Right.
So it's officially in session.
So instead of having every senator there, most of the senators there, maybe they don't have a quorum, but they might have 4 senators giving a speech or something like that. So it's pro forma. But there are people there. And, the president at that time, the Republican, George Bush, he did not...
he didn't try to appoint people
he didn't try to do
around the Congress.
Well, he declined to unilaterally select officials, right? That's what the most recent president has unilaterally selected officials without going through Congress.
Wait a minute, whoa. This is a constitutional issue. This isn't about just I want to make an executive order that I can do whatever I want.
That's why we call it constitutional.
Because there's a balance of there's something that we have. It's called a balance of power.
Right.
Congressional, executive. I mean, come on here. So you're trying to tell me that the president unfortunately decided that on his own opinion that the Senate wasn't in power. I mean, wasn't in session. It wasn't in session. So I'm going to appoint 3 pro-union people to the NLRB, which is in charge of controlling all labor board issues in the country. Is that what you're telling me?
Right. Well,
okay.
Well, when you look at the NLRB, it's a pretty powerful position.
Completely.
I think there's a couple seats missing. Right.
Well, you have to have a majority. It's three. You have to have at least.
But
three.
I think they can have 5 or maybe.
Yeah, they're supposed to have 5, but they only had 3, and those were the 3 appointees that we're talking about here.
So almost all the hundreds of decisions that have made have been pro-labor, or you could say that if you're a business person, it would be to the detriment of business.
You're talking about the Boeing, when Boeing was told they couldn't leave Washington State because they're moving to a right-to-work state that does not have unions.
Well, there was that amongst that, but there was also things to do with voting and notice and how long a company has to prepare for a union vote.
Oh, you're talking about the open vote.
Open
union vote, whether you want to choose to change a shop into a union shop, and instead of the secret vote, the secret ballot, which has been in history, no, we're going to open it up so now you're intimidated if you show your vote to the next person. Well, that's a union man.
Okay, there was also,
or woman.
There was also, some issues about how long you have to give notice before you hold the vote. And so, in other words, you have lesser time. You used to have a longer time. They shortened that so the business doesn't have very long to lobby.
Prepare an opposition.
To lobby, yeah.
And lobby the people.
Right.
But you know what? This is interesting because I understand in that case that the 3 judges voted unanimously.
You're talking about the D.C. Court, yeah.
Yeah, the D.C. Court, to say that they're voiding the decisions made by the NLRB, specifically in the Canning case, but that they reach across the board, and it's all the decisions have been made by this, because all 3 representatives that were appointed in an alleged in recess session, which was actually in pro forma session, those 3 are invalid. And that means all of their decisions are invalid.
And looking at the history, it's interesting because in the 18th century, when the Senate went on break, they left for 9 months.
Right.
So it would make sense that, you know, if the Senate's out of town for 9 months, I guess if they're going in a buggy or something, it takes a while to get back to Florida,
Virginia,
right? Yeah,
Florida,
wherever you've got to go. So, you know, it's not like today you jump on a plane. So it made sense you'd have recess appointments when the Senate wasn't in session if they take 9 months off. But I think in this time, you know, the Senate's pretty available. Someone can jump on a plane and be there Monday usually.
Well, see, this is the problem, because the concept of recess has completely changed. Now the recess that you normally have is maybe over the Christmas time or possibly Easter. And the Senate takes normal vacations, but they normally, most of the time, everybody's there, or at least a percentage are there. And because of these pro formas, they're specifically left there, so there could be no recess appointment.
And there's also some other interpretive issues, not only with the recess appointment, is like whether the person who was previously there left during a recess. And then, you know, there's also a question is like, well, wait a minute, no, you're only supposed to appoint people who leave during a recess. Like if you had a 9-month recess, it would make sense. Someone retires or dies or gets killed, and you have to appoint someone in a 9-month period. And, you know, in a short period, that doesn't happen very often now. I mean, you don't actually have someone resign.
Well, you don't run those circumstances. Those circumstances don't even come up.
So there's also that too. It's like whether you can do a recess appointment at all if it was vacant for 6 months while the Senate was in session, and you wait for the 2 days that they're not around. Is that valid?
There's actually more to this, because the president actually didn't even put anyone up for nomination. So it wasn't like he was trying to get people nominated that were being rejected. It was like he didn't even appoint anyone for a nomination or recommend anyone to fill those positions. So when he actually made those recess appointments, those people had never even been put up to be determined whether or not they're qualified to do the job. And I would say that people that were union organizers are not really supposed to be in charge of whether or not a private company can use a union or not use a union.
Well, you would think that the NLRB probably would have a split board. You know, they'd have some business, some labor. You know, you'd have something like that. I mean, that would be, you know, that would be maybe a little more fair. Okay, so, but this kind of goes to the constitutional question of you know, Alexander Hamilton, you know, in the Federalist 70, he said that, you know, you look at Article 1, Section 8, and the president of the executive is supposed to have a lot of power to protect us from foreign attacks.
Right.
And so, but it's not, you know, but to be an instigator of domestic revolution rather than protection of national security and enforcer of the laws. So when the executive used that power in a domestic situation, that large executive power, that's not as a lot of the framers had intended the executive to use. In fact, they intended Congress to have, you know, the power in domestic issues.
Well, I know, Mark, and what we're going to have to do is we're going to have to wait and see how that's appealed by the administration.